Hi, guys. Good morning. Happy Tuesday. Hey, Chloe Joe, Chick, Penny for your thoughts, Navigator. Good morning, good morning, good morning. If you haven't done so already, would you guys mind giving me a thumbs up on the stream? Give me just one little momentito because I made this thumbnail and live when I wasn't all the way awake, and I've just noticed that I misspelled arguments, and that's really going to bother me the entire stream if I don't fix it right this second. So let me fix this really quick. I apologize. Just a second. It just doesn't look right, but I guess that is how you spell it. Okay. There's no E, Jen. Come on, get your life right, ma'am. All right, let me fix this real quick. How's everybody doing this morning? I hope good. I hope everybody had a good Monday and everybody's awake and refreshed. Clearly, I'm more awake now than I was when I, made this thumbnail. Wow, Jen. All right, give me just one second. So today, obviously, as you can tell by the title of the live, it's going to be the closing arguments in the Wisconsin versus Darrell Brooks trial. Brooks is accused of driving into a crowd of people in Waukesha, Wisconsin, and during a Christmas parade, and unaliving 6 and injuring 61, including the dancing grannies, and there were children. It's a Christmas parade. He has been disruptive and disrespectful in during this entire case. He's argued with the judge, he's interrupted the judge, he has argued with, which it's okay. It's one thing to argue with the prosecution, right? It's a trial. Um, you know, it is what it is. That it happens. However, you're not supposed to speak over each other and it's just he's just been really rude. And it's caused quite a disruption. Now, the other day, what happened, not yesterday, but the day before. So, what happened was Mr. Brooks wanted to introduce this letter to the court, and he wanted to recall. Hi, Utter Nutter. Good to see you. Hey, Max 2002. Good morning or good afternoon. For Kezchik, it's good evening. Anyway, so evidently his mother, the vehicle that was used in this crime, allegedly, right? Because he hasn't been convicted. Um, there was some type, excuse me, there was a recall notice, okay? And this recall notice was given to his mom because the vehicle is registered in her name, okay? And he wanted to submit that letter. And the judge said no. And the reason that she said no is because it was a time issue. This information would have been available way earlier. And so she said, you've had ample time to let me see this real quick. You've had, oh, good. At least I spelt it right in the title. But I didn't in the description. What is wrong with me? I'm actually a very good speller. All right, let me fix that. Sorry, you guys. I know that that's really petty, and I'm supposed to be focused on talking to you guys, but I can't go around with having a misspelled word. That's just not going to work for me. Okay. So now we should be good. Let me just make sure that YouTube hasn't. Okay, perfect. Changed the live chat replay. All right. So anyhow, the judge said, no, it's a time issue. You've had plenty of time to, submit this. And quite frankly, it really, there isn't anything in the letter or that he wanted to recall a witness from the, what was it now? Oh boy, I'm drawing a blank. Like an expert witness about having to do with the recall, okay? And the judge said no. And the judge and Darrell Brooks got, hey, Marshall Dave, welcome, thank you. Did I say hi to Navigator? Hi, Navigator. If I haven't said hi to you guys, I'm so sorry. You guys know how I get. Amelia Sparkles, good morning. You guys know how I get. I'm easily distracted by um, small details like misspellings, and I had to fix it. And now my whole live is thrown off. Okay, let me try to reorient myself. Okay. So Mr. Brooks was upset, angry um, at that fact. And he became disruptive. And so consequently, he was moved to another courtroom. And I have to say that I feel like both the judge and the prosecution have not only have they been the consummate professionals, but they have been exceedingly patient, especially the judge, because all of the things that she has been doing thus far are really to for the benefit of Mr. Brooks. There's going to be a jury instruction that the fact that Mr. Brooks at times was either that he was removed or he was placed in another courtroom. I should say moved. I think that's the actual instruction. The fact that he was moved to another courtroom should not have any they shouldn't deliberate about that. It doesn't mean anything one way or the other. And so yeah, I I that is absolutely 100% to protect Mr. Brooks. Um, I just wanted to pop over real quick to the Pike County trial. I believe that Jake Wagner is going to continue his testimony on direct today, which obviously he has opted out. I just wanted to see what's happening. And then there'll be cross exam. And there will be more witnesses today. And I don't think that those witnesses have opted out, but we'll see. What are you doing, Jen? Get it together. Let's see. Hang on a minute. The other thing I wanted to tell you guys is that the jury instructions are 107 pages. So, bro, what is the deal here? Here we go. And the feed is set to start at 9:30 a.m. Now, I believe, if I'm not mistaken, hey, N5678. I believe that the way that the judge said this was going to go is jury instructions, prosecution, defense, closing statements. Yeah, I think I'm gonna have to make myself another cup of coffee, quite honestly. I don't think I had enough. And even though I had a 5 hour and coffee, as is my routine, it's not enough. Like, not the synapses ain't firing, if you know what I mean. So, anyway, but given the fact that, so one of the things that the judge said is that she expected Mr. Brooks to be able to begin his closing arguments this afternoon, right? Um, she also had said it's going to take something like 5 or 6 hours for the jury instructions to be read because it's such a lengthy document. There's a lot of there's a lot of instructions because there are so many victims. He's got what, 61 plus 6 is 67, that's just covering the victims, right? There's other counts as well. Hey, Dylan Hawkins, welcome. Yes, that's correct. He because of his outbursts and poor courtroom etiquette, he forfeited his right to testify. Um, and then it's really up in the air as far as did I say Marshall Dave? I meant to say Marshall Dove. Sorry, I'm way off today, but welcome. Thank you, Marshall Dove. Okay, so yeah, he forfeited his right. So we're at the jury deliberations. Now there's so the jury instructions are intended to be long, and I'm kind of thinking that it's what will happen is she's not going to read the jury instructions for 5 to 6 hours straight. So probably it'll go today in court this morning is she'll read some of the jury instructions. The prosecution will do their closing arguments. There'll probably be a break. Mr. Brooks will do his closing arguments. The state, if they have time left, will be allowed a rebuttal closing argument, and then she'll read the end of the jury instructions, and then the case will be sent to the jury. That's what I think should happen. No, it's not that, your name I was confused, to be honest with you. I just didn't I have my glasses on, but I wasn't looking at the part that helps. I have to have readers, and so sometimes I can't see, and so I got old. I've always had an astigmatism, but the older I get, the worse it gets, so yeah, I'm all discombobulated today, you guys, for reals, for reals. Like, this is I can hear it myself being discombobulated. And I'm even kind of like annoyed with myself. Like, get it together, Jen Lu. Sheesh. So it's a mess. I'm a mess sometimes. I try to be professional as much as I can be, but I'm human too. So, and this is just part of the magic. What is me? I guess. So anyway, that's what's supposed to happen this morning. I do have, oh, let me share screen so I can see whenever they start court, because we definitely don't want to miss any of it. And I know what I was going to say. There's really a lot of, I'm curious as to what his closing arguments are going to be, mainly because, quite frankly, the way that it was left the other day, I guess yesterday it would be, when he was like, I'm going to tell the jury whatever the hell I want to tell them. I'm gonna tell them the truth. And the thing is that to me, what it sounds like is that Mr. Brooks is going to try to attempt to basically testify in his closing arguments, and that's not allowed. It's just not, that's just not the way it's done. If he wanted to testify, what he should have done is he should have straightened up and acted right. And then he could have, put himself on the stand. And the thing about putting it actually worked out for his benefit in a way that he acted the way he did and that he was removed and forfeited his opportunity to um, testify because, quite frankly, under the best circumstances, it's difficult for it's a risky move for a defendant to take the stand in their own defense, and that's when they have a professional attorney giving them direct examination. But when you're representing yourself, it's a little bit different. It's, obviously, number one. And number two, of course, you open yourself up to being cross examined by the prosecution. And prosecutors are known for taking the opportunity, which is this is exactly what they should be doing. But their whole entire goal when you testify in your own defense is to trip you up on the stand during cross and get you to admit things that you did, and that's just the truth. That's how it goes. So it's a risky move. So honestly, the things that he said to the judge yesterday, like she was getting slick with him and he's been disrespected this entire trial and all of these proceedings and stuff, the truth of the matter is actually he hasn't been. And she has been more than patient with him. I mean, for Pete's sake, y'all, she must have asked him, oh my, at least 10 times or more. 10 times. I stopped after the 10th time. I stopped counting if he had anything that he wanted to discuss as far as jury instructions. And he just, you know absolutely refused to act right. And I just don't know. I mean, you have to give it up to the judge, to everybody in the courtroom, really, because this is this is a sad. I mean, every case, right, that deals with death is sad and it's tragic, right? This one is additionally tragic because the way he is behaving in court, in my opinion. Now, I understand wanting to defend yourself, right? And he's pled not guilty, and that's his goal, is to be acquitted of these charges. I understand that, okay? That's not why I feel the way I feel. His behavior and the way he's conducted himself during these proceedings is a slap in the face, if you will, to the victims. It's disrespectful to the victims of this crime, even if, like, he's saying he didn't do it, right? So wouldn't you? And if I understand being frustrated, um, being accused of a crime you say you didn't commit. Now, I'm not saying whether I don't think that he should be acquitted. I think he's guilty of each and every single charge and each and every single count. I think he's guilty, and that's based on the evidence. Hello, Lorianne. And the truth of the matter is, but let's put that aside. Let's say, for argument's sake, that he's frustrated because he's actually you know didn't do this. Okay. I get being frustrated, right? But hello, why don't you, conduct yourself with, just keep in mind why you're what this case is about, and just, can't you just act right? Hey, Jody is cool. Good to see you, babes. I just don't understand it. I don't even know what he was thinking representing himself. I really don't. And I have to say another thing respective to the judge is that, you know, he has, he's representing himself, which is always, um, if you're not an attorney, it's very, or even if you've never even gone to law school, like you don't even have a little bit of legal background, right? Maybe you didn't finish, but whatevs. Um, what I don't understand is, or what I'd like to say about that is the fact that she has been really careful about the way she's conducted this trial thus far in ensuring that his rights are not dismissed, that, or I shouldn't say dismissed, ignored, or there's no opening for a potential, what's the word I'm looking for? Um, uh, Appeal, because his rights were not ta honored in this trial. And so, she's been, I think, in my opinion, she's gone above and beyond. What's next? I have to say, I agree with you. Even, I mean, what's that saying? An attorney who represents themselves has a fool for a client. I just think that even if, I mean, it's it seems to me that, and we've seen this in a couple of cases, the Trevor Summers case, where he had been back and forth being pro se and then represented, and then at the last minute, um, well, not even at the last minute. The truth of the matter is, during his ex-wife's testimony on direct, because she testified for the state, he stood up, or his attorney stood up at the morning break and said, "Hey, he's decided that he wants to represent himself," and he did that because he wanted to question the ex-wife. It wasn't bad enough that she had to testify to what occurred when she was kidnapped and held hostage, and all of those things that occurred, because it's hard as a victim to get up there, and your accuser is sitting you know really close to you in a courtroom, and that's just because of the way the court is set up, right? And he did it because he wanted to question, he wanted to cross-examine her. And I feel like Brooks did the same thing. I think that he chose to represent himself because he knew that the state was going to call his ex, and they did, and he had an opportunity to get up there and cross-examine her. And it's just, you know, it's sad to me because, like, I respect the process, right? And the anybody who is on trial, has a criminal trial, and in a criminal trial, has the right to face their accusers, okay? And um but the victims have rights too. And I think that I don't know what we can do to change that, because if we were to amend some things, specifically the Constitution, which is very difficult to do. If we were to amend the Constitution that says that you have the right to face your accuser, right? Is that in the Constitution? I have to look that up. Bottom line is, look, if we were to change whatever it is, wherever that's written, I think it is the Constitution, that you have the right to face your accuser, you have the right to a fair and speedy trial, yada, 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 right? Then it, in order to protect victims, then it would be like, you don't, it would, it what might impede the defendant's rights. So it's a weird, sticky situation that I don't even know how it can be resolved. I don't think that it can, other than, I suppose, that victims get additional support before and after testimony, especially when they're good morning, sugar beet. Good to see ya. Especially when they're being questioned by their alleged perpetrator. So, yeah. What time is it? Okay, we only got a couple of minutes. And I will say, this courtroom has been great about starting on time. I'm also kind of curious, just on another note, because I'm thinking about the Pike trial, because I've been covering that shoot since it started. I'm curious how long cross examination will be, because to be honest, thus far, cross examination hasn't been all that long. Like, even with um, the two ex-wives, Tabitha, who is, excuse me, George's ex-wife, Beth, who is Jake's ex-wife. I want to tell you guys that the cross-examination, maybe at most, was a couple of hours at most. And I actually think that might be a couple of hours total between both of them, like an hour each. Hey, Chick Tracy, good to see you, babe. Um, yeah, I don't think it was very long. I'm curious how long it's going to be with Jake, because they definitely, I will try to. I mean, they're going to come at him with the you took a plea deal, so you have a reason to lie. You've changed your story, so you are a liar. Do you know what I mean? Um, yeah, I'm very curious, and I want to know if they're successful in scoring some points with the jury. And the only way for me to know that, obviously, is to be able to hear the testimony, which again, Jake Wagner, boo on you for opting out. You should have to face the music. You know what's interesting though, y'all? And I just thought about this. I just thought about this. So, if Ohio law is such that witnesses can opt out, video and audio, or just opt out of video and allow audio to be played. Wouldn't it be something if they opted out of audio and just allowed video? Um, Obviously, that makes no sense, but just, whatever. Anywho, how come during the plea, uh, during his plea, right, when he took the plea deal, he had to stand up, he had to answer. I guess he's not, no, because he was sworn in during that plea agreement, or the plea hearing, excuse me, I should say, when he entered a guilty plea. How come he didn't or couldn't opt out then? I wonder if he had the choice. And I'm wondering if the reason he opted out this time is because last time when he took the plea deal, right, there was a smirk. He made a smirk, and everybody, which they're right, lost their minds because it was so disgusting. They were so angry, and I don't blame them. And lost their minds isn't really the right term, because they were just, I mean, I myself too, when I watched it, I was like livid. Oh, speaking of watching things. Okay. So I don't know how many of you, I think I know a few of you in here have been, because I've seen you in other chats and stuff, have been keeping up with the Quentin Simon case. Okay. So, over the weekend how there were allegations that Leilani was dancing in the windows, I suppose the window, and essentially taunting protesters. Okay. So, your girl here was like, that was really like weighing on me, because I could not understand. Uh-oh. Hold on.
and the 14th Amendment due process rights. I make a reservation for those rights, especially, but all rights at this time.
The record to reflect that the individual known Darrell
Oh,
Brooks is present in person in custody. He is appearing today in street clothes. He has a dress shirt and a tie on. He's also wearing a mask.
And I don't consent to being called that name for the record. As this paperwork I accept for value and return for value, as it does not state the correct name. It states the name of my client, the straw man. I am not this name in all capital letters. I do not identify by that name, nor do I know that individual.
Your objection is noted. It's baseless in law and fact, and that is simply a caption on a pleading
That
on
is
the
not my name.
final jury instructions.
That is not my name for the record.
Right, the
don't
record should
recognize that
reflect,
name or-
Mr. Brooks, I'm talking. The record
I
should
don't.
reflect that at 3:23 p.m. yesterday, all of the verdict forms were printed off and provided to Mr. Brooks. I also provided him with an excerpt from the bench book on closing arguments. I left a copy on the state's table as well, and a second copy on the defense table today as well, so that I thought that would be helpful information as we are about that time in the proceeding for the parties to give their closing arguments. Of course, prior to that, the court will be reading through the final jury instructions. The parties were also given the updated version following the jury instruction conference yesterday as well. The total number of pages for that is 107. The court will be reading from the first 73 pages this morning. I do anticipate having to take one or two breaks before I complete all of that. My plan is to do that and then take the lunch break. And then when we come back from lunch, to have the parties provide they're not opening, their closing arguments. And then following the closing arguments, the court has the final jury instructions, which go through the closing instruction, instructions 460, 484, and all of the verdicts. And then the instruction to the jury 515 about their verdicts needing to be unanimous, and then selection of a presiding juror. The very last page, 107, actually is not read until the close of the case and only following receipt of verdicts or some other type of disposition that would result in the conclusion of the case. It's the instruction after the verdict is received. So page 107 is not something that will be read today. As indicated yesterday, I will be selecting the alternates by random selection. We'll use the tumbler and select 3 numbers out of that, but that will be done after all of the instructions are read and the parties have an opportunity to give their closing arguments.
oh, right, Navigator.
Your Honor, I accept for value and return for value any documents that you just alluded to. I have not seen them.
Mr. Brooks, if you haven't seen them, that is by your choice. They were provided to you. I know on multiple occasions yesterday you threw items into the garbage can. The court retrieved the final jury instructions. I personally didn't. I had someone do it, had them placed on the table this morning, and any other items you threw in the garbage.
So is that the paperwork that I had to stay here for over an hour for?
Sir, I'm not going to discuss any further what we did during the jury instruction conference. The jury's going to be brought
Jury
out a
instruction
little
conference.
bit later.
There was a conference. We talking about the proceedings from yesterday, or after you had told us we recessed
Mr.
for
Brooks,
I'm referring to after you called recess for the night yesterday. That's what I'm referring to. I was put in the holding cell for over an hour because they said it was some paperwork that needed to be.
That is correct, sir. You were kept there in order for my clerk, who had to finalize 76 verdicts, 2 each, 1 not guilty, 1 guilty, and provide those to the parties.
Is
And
that
so
the-
that's why you were kept there, so those could be handed to you. My understanding is they were. I would need a bailiff to confirm for me whether he took those back to his cell or if they were put on his desk because he left them in the holding cell.
Left them in what holding cell? In here?
How many holding cells have you been in, sir?
I have to look through his paperwork to see if they're on here.
What holding cell are you referring to, Your Honor?
Behind the door.
I didn't leave anything in that holding cell. I was just trying to figure out why I was in there so long.
She just told you.
Are those the verdicts?
Yeah.
All right, he has those. Thank you.
Excuse me.
Is this the paperwork that was just put on my? It was paperwork on the desk when I came in.
That's it.
That was on top of my folders.
Bless it.
Mr. Brooks, I know that you were given the opportunity to take them to your cell because that is what I was advised. Whether you did that or not, I don't know.
That's
But they
not
are
what
also on your desk now.
I accept for value in return for value any documents.
Huh?
We did discuss all of the jury instructions and the verdicts yesterday.
So what was discussed when I was in the cell for over
There
an
was
hour?
no discussion, sir. The court was in recess. Madam Clerk was simply finalizing the paperwork based upon the discussion that was held on the record in open court.
While you
yesterday.
were
I was
building
told
a box
that I had
fort.
to stay there per you.
Yes.
Yes, so that we could provide them to you and you would have an opportunity to take them back to your cell.
But
should
can
you
they
wish
can
to
they have
review
been
them.
delivered to the jail?
All right, I don't believe there's any other preliminary issues we
There are.
need to address other than an advisement I will have for Mr. Brooks. But let me turn to the parties and ask if there's anything preliminary to this phase of the trial, which is the jury instructions, the verdicts, and closing arguments from the state.
No, Your Honor, thank you.
All right, anything else from you, sir?
Yes, there is.
Here we go.
Yesterday, I stressed to the court numerous times about me not understanding the proceedings, and essentially how
Hi,
decisions
Shamina.
are being made on my behalf without my understanding or giving consent.
Bless it.
The court made various rulings yesterday. I made findings and ultimately made some determinations. I stand behind the record that was made. I'm not going to explain it further.
So a lot of those decisions were made when I was not present in the courtroom. I was in the other courtroom,
That
correct?
is true, sir.
Is that correct?
The record will indicate when those were made and where you were.
I can't see the record though. How am I supposed to know what the record will reflect?
Sir, the decisions were made yesterday. I'm not revisiting them today.
They need to be revisited, and it also needs to be talked about. Subject matter jurisdiction that has yet to be proven for the record.
Bless it. Are we still on this?
I'm still trying to understand, Your Honor, how you made a judicial determination on my behalf, which I did not give consent to, as you say, I forfeited my right to testify, which I never did. I never said I wanted to. I never said I didn't want to, but that decision was made for me.
Yeah, you're by
Also,
you.
the decision for the defense to rest its case was made for me, which I did not consent to, nor did I say I was ready to rest, or nor did I say I did was ready to rest.
Okay. All right, Mr. Brooks, I'm going to tell you over here, even though you can't hear me, but I'm going to pretend like you can. I'm going to tell you what the judge has been too nice to tell you. Okay. No decisions were made for you without your consent. Let me tell you what happened, sir. You acted a damn fool. Okay. And the judge warned you repeatedly. Bro, if you were in daycare, you would have your card on red. You would have had to pull your car from the green to switch it to yellow, and then you escalated that shit all the way up to red. That is what happened, okay? You're familiar with the term timeout. That's what yo ass was, timeout. But you were not left out of the proceedings. The judge was kind enough to put you in a different courtroom so you could get a hold of yourself, okay? And put you on Zoom. you decided the better idea for you to do, like a toddler, would be to have a whole ass temper tantrum from behind your box fort. Okay, that is what happened. That is why we are here today. The subject jurisdiction has already been decided. That's ridiculous subject matter jurisdiction. Excuse me. Got me all riled up this morning already. Now, let's continue.
I'm trying to understand how all these decisions are being made with without my consent, without me waiving any rights.
Your behavior waived your rights.
I'm not
Like I
understanding
said,
how, because none of my answers were unresponsive. I just didn't answer the way that Your Honor wanted me to answer. But I stressed yesterday, if I don't understand something, how am I supposed to answer a
well,
question
that's
that I don't
behavior, babe, is what I
understand
meant. But yes,
fundamentally?
you're absolutely correct.
It's not me saying yes or no, and it's
Hi,
not me
good
saying, okay, I want to
morning,
waive
bitch.
this
Good
or
to
that
see you.
right. And I'm not trying to make an argument with you in any way. I'm just seeking to understand how these decisions are made. If I'm letting the court know and I'm putting the court on notice, hey, I don't understand this or I don't understand that.
It's not the court's
Any other
responsibility
things?
to
Otherwise, I'm
explain
prepared
the
to
legal
address each one of
process
those.
to you.
Yeah.
You elected to
There was
represent
a
yourself.
mention of if there is a conviction in this matter, there's a mention of sentencing, which I'm assuming there'll be some type of um, um, people may want to speak. I know if there is a conviction on my half, people would definitely want to address the court. Um, there'll be a lot of affairs that need to be put in order, obviously on my side.
Not fears, y'all. He said
Um,
affairs. Get
if
your
it pleases
life
the
right.
court, if there
Closed
is
captioning.
a conviction in this matter, I would like the sentencing to not be so quick. I'm asking if it pleases the court for the sentencing to be held off into a later time, not a day or two or a week, just so that affairs can be put in order properly, and so that the people that want to come in and speak will have the opportunity to address the court.
I think that's a fair request, sir.
If that pleases.
I think that's a fair request. I thought about that and some more overnight, that in the event there is a conviction, that I would like to give the parties an opportunity to do that. I have no idea how many people would want to speak. My inclination would be, again, and this is not set in stone. If there is a conviction on any of these counts, I may ask the parties to just come back in on Monday, October 31st, with kind of a proposed plan of how many people do you think will speak on your behalf? How long do you think it will take? So that I can look at my calendar and then set aside the appropriate amount of time. I
Bro,
certainly don't
vodka
want to
would
rush
not be enough for
anything.
me. I'd
And I
need
think
some
that's a fair
Xanax. I'm
request
not
that
even
you're
go front.
Thank you.
All right. So
Or
with
Valium,
all of
any
that,
of the
then, sir, subject
benzos
matter
would be
jurisdiction,
fine.
I decline to address that further. I stand by the written decision that I've made previously. As far as the rulings made yesterday regarding your ability or inability to present further testimony and witnesses and to testify yourself, the court did make various rulings and findings that you had forfeited your right to do so by conduct. I'm not going to further explain the law or these prior rulings to you.
Allie, literally, his attitude just switched in in those last moments. He was very confrontational at the beginning of this situation, and I already had to explain to him about what had happened and how essentially he behaved like a toddler. And so what had happened was his card was pulled. He started out on the green, then he went to the yellow and ended up on red, which is why his ass was removed and put into another courtroom. And then he wants a deal. He wants a favor from the court, so he amended his tone and acted correct properly, which I guess that's what's so additionally frustrating is it's not like he's incapable, right? He knows he chooses when to act right and act left, if you will. All right, here we go.
I stand behind them, and I believe I made a very, very clear record. So to the extent that you are asking me to reconsider any of that, that's how I would interpret your statements here today. I decline to do so.
So, Your Honor, would that be that's still not, I have no understanding to
You're welcome,
why I
Allie.
wasn't given the opportunity to place certain things into evidence. I have virtually nothing, zero evidence that I was able to place into evidence. Nothing.
I disagree with that, sir. You called, I think, 9 witnesses on your behalf on various issues, including the honking of the horn, the window tinting. You cross-examined many of the state's witnesses about police barricades and the presence of police. So you did present evidence.
I'm speaking to the terms of everything that Your Honor asked me to do. You told me to put everything that I needed to present to the courts in writing. You made that ruling. You told me that's what I needed to do.
That's the rules of
I
evidence.
did that.
Mr. Brooks,
It wasn't special
you
just for
may have
you.
interpreted that. I did not require you to do that. As far as evidence in the case, I very expressly told you there are rules of procedure and rules of evidence that govern exhibits, testimony, witnesses, etc. What I told you is that any requests that you have related to the case, if it's a motion, be put in writing. I specifically referenced the statute 80201 regarding how a motion is made and what it should contain, meaning it has a very express request for relief and states the law and the facts upon which the request is being made. Again, I'm not going to revisit the prior rulings. I stand behind them. And to the extent that the record does not have, meaning the record before the jury and the evidence does not have certain pieces of information, evidence, or testimony that you wanted to present, you forfeited that opportunity yesterday based upon your conduct.
How did I forfeit the opportunity?
Again, I'm not going to revisit that, sir.
How did
What
I
I will tell
forfeit?
you is this.
How did I forfeit
This
the
jury is
opportunity
here.
to be able to place into evidence?
Mr. Brooks, I'm
that
not
need
going to
be-
debate this further.
I'm not trying to debate. I'm trying to
to
understand.
respect the fact that I've made rulings.
Your Honor, that's you
It's
made
not
a
my
judicial
job to
determination.
explain them
You made
to
it.
you.
I'm not asking you to explain anything. You're misinterpreting what I'm trying to ask you and trying to tell you. You're misinterpreting it. With all due respect, Your Honor. When you tell me this is what you need to do, I'm going to take it by what you're telling me that I need to do. If I needed to make anything request-wise or anything that I needed to present to the court, it has to be in writing. You told me to do that. I did it. You also brought up when I asked numerous times before when would I have a chance to present things into evidence, you told me we were not at the evidentiary phase of the trial yet. So I took that as saying, okay, well, at some point I will have the opportunity to place things in the evidence that need to be put in evidence for the record. So I'm not understanding how
I'm not understanding how you're not
a decision
understanding.
can
How
be
about
made
that?
for me to actually forfeit being able to put things into the record that need to be placed into the record. All these things are things that, quite frankly, allow me to put on a defense. Things that need to be known, things that should be in the record, as far as filings, as far as ICFs that I was told to by you to address certain ICFs either to you or to the clerk of courts, which I did, and received copies for all of them except until last week. It was a few of them that I didn't receive copies for that I'm still wondering why I haven't received those copies when I received the copies of all the ones before that. But in terms of that, I did what Your Honor asked me to do. And these are things that were part of my defense that needed to be placed into the record. So where my confusion comes in is not being able to place those things into the record. Things
Mr.
that
Brooks, I'm
things
gonna cut
that
you off
clearly help my
because
defense.
I stand by my ruling. I'm not revisiting it. To the extent that you claim lack of understanding or your lack of consent, it's been made abundantly clear on this record, your position on that. I'm not revisiting it. I'm further advising you that when this jury comes out, I expect that you will honor the decisions that were made, not agree, but you will honor them and not interrupt the court or these proceedings as I instruct the jury.
So how am I supposed to put these things in the record that need to be in the record?
Mr. Brooks, I'm well aware of the effect my ruling had, and I'm not going to debate it with you further.
I just want to know, how am I supposed to get these things on the record? How am I supposed to, because the filings that I gave, you actually filed and gave me the copies back. So are those in the record?
Mr. Brooks,
I'm
I'm
just,
no longer
I'm
going
just
to
seeking to
talk about
understand.
this.
I'm just seeking to understand.
Mr. Brooks, I cannot explain procedure or
The
evidence
filings that
or
I
the
filed.
rulings or
I'm
the
asking a
law
question,
to
Your Honor.
you.
I'm merely asking a question. The filings that I presented to Your Honor.
Any filings
For
with
the
this
court.
court are in the court record. That does not mean they're evidence, sir. And I told you
That's
that
not what I'm
previously.
asking. I'm
Oh,
asking,
bless
are
it.
the filings part of the record?
That's what she
The
just
filings that
answered you.
Were
Yes.
filed and timestamped, that were notarized, that I presented to the court. All the filings, the appearance bonds, the statement of particulars, the notice of special appearance, the court docket sheet, your oath of office, everything that I tried to present into the record. How am I not able to make them part of the record?
So they were filed because you presented them to the court during the course of this case. Anything that was not offered as an exhibit and received during the evidentiary phase is not evidence in this trial.
That's what I attempted to do, and you told me that I couldn't. You told me,
Mr. Brooks, I am bringing this jury
Your Honor,
out.
with
Listen
all
to me.
respect, you told me that we were not
Oh,
at the
sweet
evidence. When I said I
Jesus.
have exhibits as well, I have stuff that I want to put into the record. I even asked, I said,
Mr.
may I
Brooks,
give an offer into evidence?
I'm going to stop
these
you
things.
once again. I'm not
I
going
will
to
be
have
right back.
this discussion and debate.
I'm just going
The
to mute, but I'll be
evidentiary
in the
phase of
chat.
this trial is
Okey-dokey,
closed.
artichokes.
It
We
should
are
not
now
be, though,
at the
Your Honor.
jury. I understand your lack of consent. Your
So
objection
when would I
is
be able to
noted
put?
for the
When would
record.
I be able to put vital information into the record, which I haven't had the opportunity to do?
That opportunity has closed for you, sir.
So you saying basically you're prejudicing my defense by me not being able to present things into evidence, offer into evidence, filings and important paperwork and documents.
Mr. Brooks, and you
How am I
forfeited
not-
your right to do that by your conduct yesterday, and I stand behind that decision.
I
I'm going to
asked
do the
before
following,
yesterday,
sir.
Your Honor.
I'm
I
going to do
asked
the
this before
following.
yesterday.
You have not honored my request to you that you cease debating me on prior rulings
I'm not trying to
of the
debate.
court.
I'm trying to understand why my due process is being violated.
Mr. Brooks, the record speaks for itself.
No, the
I
record
am
does
going
not.
to take
It
a
does not.
5-minute recess. When I come back out, the jury will also be coming out. I'm advising you there will be no multiple opportunities where I give you to conform your conduct to the rules of decorum.
Well, then
courtesy.
just hold me in
You-
contempt, then, Your Honor.
You are
Hold me in
hereby
contempt because
advised
I didn't even. I'm trying
that
to
if
seek to
you start
understand.
talking about subject matter jurisdiction or any of these other
It
issues,
needs to be addressed,
or
Your
in
Honor.
any way
We're not talking
interrupt
about subject matter
the
jurisdiction. We're
reading of
talking
the jury
about why
instructions,
my due process
I
has been
will
violated.
excuse the jury and you will be removed
Your
to
Honor,
the other courtroom.
We're talking about the 14th Amendment,
Right.
Section
I am
1.
taking a 5-minute break. We are
Your
in
Honor,
recess.
I don't
When
agree
come
to a
back out, the
estoppel.
jury
I
will be
don't agree
coming
to a
as well.
estoppel. Your Honor, as a
Okay, I'm back. And because I paused, we're behind. So let's scooch, 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 scooch it up. Still on break, which is fine. We all need a break. Oh, good. I'm glad you like it, Kez. Yeah, sometimes I gotta take a minute because I'm trying really hard to be patient and not crack too many jokes. But while we're on this break, real quick, I do want to say that every time he says, "That's not my name," I hear the Ting Ting song. That's not my name. That's not my name. That's not my name. Every time. Oh, I didn't scooch it enough. Hold on. Also, let me just click this. Hopefully that'll do it. Thank you. Because YouTube has done changed some things around and they be making adjustments that I didn't authorize. Maybe Jolisa. That's not my name. Oh boy. I don't think this is going to go. Okay, let's have another little question for the audience. They call me Stacy. They call me light girl, but I'm a white girl. Yeah. Jen should not be singing. I think what do y'all think? How long are we going to have in these proceedings this morning before Mr. Brooks is excused and placed in a different courtroom? What do y'all think? You know what else? Just while we're waiting, every time he says that, and I hear the Ting Ting song, I also see the scene from Horrible Bosses where what is his name? That's Charlie Day is like lip syncing and dancing along when he's waiting in the car every single time. Like I can't hear the Ting Ting song and not see Charlie Day. Um, you know. Uh oh. Okay, here we go.
Your Honor, it has yet to be proven for the record. And upon your
Already.
refusal, that would be looked at as dishonor.
I'm not addressing it. The jury's coming out.
So is that a tacit agreement that you don't have to answer any questions as a public servant, Your Honor?
Oh boy.
Therefore, that's dishonor. Are you going to honor your oath of office?
Stand. I'm not addressing it
Are
further.
you going to honor your oath of office?
All rise.
So I'll take that as a tacit agreement that you're not going to honor your
All
oath
right,
of
I'm
office.
going to have to excuse the jury.
Every time. Come on. 2. I think we're back live for, I don't even think it's been 2
Mr.
minutes.
Brooks, I warned you that if you made any interruptions when they came out, you would be removed to the courtroom. That's what I'm doing right now. You're forfeiting your right to be present in this courtroom unless you can promise me right now you'll respect prior rulings of this court and not interrupt this next phase of the trial, which is the court reading the jury instructions without interruption from you. Can you do that?
Have I acted in dishonor, Your Honor?
Mr. Brooks,
It's a yes or no question.
expressly warned you.
Have I acted in dishonor?
You have disobeyed a direct order from this court.
Have I acted in dishonor?
You have disrupted these proceedings.
I have not disrupted these proceedings.
Sir, can you pledge to me that when this jury comes back out, that you will remain silent and not reference things like subject matter jurisdiction, the court's oath of office, tacit agreements, or anything? Can you pledge that you will respect these proceedings and this jury by not interrupting?
Have I acted in dishonor?
Oh,
I will
sweet
ask you one more time.
Jesus.
Can you pledge to be quiet, sir?
Why should I? Why should I have to make a pledge, Your Honor? Have I acted in dishonor?
Because under Illinois versus Allen, I believe you've already forfeited your right to be here, but you can reclaim that as soon as you are willing to conduct yourself consistently with the decorum and respect inherent in these proceedings, which at this point in the proceedings, sir, all I am doing is reading through the final jury instructions. I do not want that process interrupted by statements by you that are frankly misstatements of the law.
If they're misstatements of the law, Your Honor, how come they haven't been proven for the record? And I'm asking, have
All
I
right,
acted
he
in dishonor?
refuses to answer the
Have
questions.
I acted in
I have
dishonor,
given
Your
him
Honor?
an ample opportunity to do so. He has forfeited his right to be present for the reading of the jury instructions, and he is to be removed to the neighboring courtroom. We will be in recess until that takes place.
Your Honor,
Thank you.
have I acted in dishonor?
Okay, bye. Bless it. Listen, don't feel bad, Allie, because hey, Mark Klein, good to see ya. It's been a minute. Don't feel bad, Allie, about the 45 minutes because low key, I think all of us, by the Price is Right rules, which is the only way I ever play, we all overbid. We all thought that it was going to be just slightly longer, and I did not, in good faith, believe that this gentleman would start his baloney the second the court came back from its recess while getting the jury. I really thought that he was, I don't know why. I really thought that he would just hold it together. But as we just witnessed, that did not occur. And so now he's been removed. This is just, ugh. I'm glad that this is coming to an end, honestly. I don't think that you know what, Penny, for her thoughts, I think his box fort making days have ended. I think that the judge has decided that no more no more box forts. Now, I will say, and I said this last night because I'm still wondering about this. I have not reached a conclusion, or yeah, I'm really curious if he should be convicted, if he will go to the same diagnostic center that Chazzle Dazzle currently resides in. I don't think Chazzle Dazzle has been placed in his permanent home. And I wonder if they'll be there together. And if they are there together, I wonder if they will have a fort build off. Because quite honestly, ain't nobody able to build a fort like Chazzle Dazzle. Like, you know, he had rooms in his fort, it was decorated, all the things. She does have a lot to read, and I'm low key kind of shocked that she's going to read the jury instructions in their entirety and then do closing arguments. And I'm just kind of shocked because it's so much, so voluminous. I really thought that maybe they would like split it up, but either way. And you know, what we can do is we can listen for a while to the jury instructions and then like take our own little breaks, and then I'll come back when after lunch when closing arguments begin for reals. And I want you to know, in doing so, I will be forfeiting my nap, which anybody who knows me at all, even just a little bit, knows how very important naps are to me. And I'm willing to make that sacrifice because I adore you guys so much. And I can't think of anybody I would rather listen to these closing arguments than with you guys, my friends. And so Jen Lu has taken the pledge to not act dishonorably and to forfeit her right to nap so that we can listen to this together. Oh, Allie, don't worry about it. I do that all the time. If I wasn't streaming right
Everyone,
now,
please be seated.
I would be
The record to
listening and
reflect that
cleaning.
Mr. Brooks has been placed in the other courtroom. He is presently on mute so that I can make a record. I do need to confirm that the audio and visual equipment and system is working. I am getting a thumbs up from the bailiff. I'll
It's
just
okay,
ask Madam Clerk to
Chick.
confirm with the clerk
It's
that's
late
over
for
there
you, babe.
as well. I would note Mr. Brooks has the headphones on. This court certainly doesn't take pleasure in removing Mr. Brooks from this courtroom once again. We are at an important stage of this proceeding where the court needs to instruct the jury concerning all of the law that will guide them in their deliberations. As I've put on the record previously, the total pages comes to 107. I will be reading this morning through page 73 prior to the parties given the opportunity to make closing arguments, and then reading from pages 74 to 106 following that. It is very important that the court do this without interruption. Yesterday, this court held a jury instruction conference where both parties had a full and fair opportunity to raise objections regarding any of the proposed jury instructions, to make requests regarding inclusion of any jury instructions that the court did not include, as well as review all of the verdict forms. There's absolutely no reason for there to be an interruption or an objection to this process at this time. The court spent the better part of 25 minutes this morning with Mr. Brooks raising issues and prior rulings that this court has spent an abundant amount of time on, including subject matter jurisdiction. He continues to claim he did not consent. That's been noted for the record. He continues to claim that he has a limited or no understanding of prior rulings and decisions of this court. I repeatedly advised him I would not be revisiting these issues, that I wanted to go forward with the jury instructions, and repeatedly warned him that any interruption once the jury came out would result in his removal from the courtroom. Again, I take no pleasure in doing that. I prefer that he be here, but frankly, the decision I made here today, with the speed at which I made the decision here today, is not only to preserve the dignity of these proceedings, but to do so in a way that avoided the court admonishing Mr. Brooks in front of the jury. This, of course, comes on the history in this case with the repeated removals that this court has had to undertake with Mr. Brooks, given his conduct and his behavior in this case. I am currently being advised that he would like to come back. That, of course, is always something that I will give him. As soon as I make my full findings, I will pause and he will be brought back into this courtroom so that he can be in attendance when the jury is brought out. Of course, my decision that I made this morning to remove him is based on the authority from Illinois versus Allen. I'd also note that State versus Anthony talks about the Allen decision along with State versus Vaughn. Those are two state court decisions. Clearly, even though Mr. Brooks was using a mild-mannered tone of voice, he directly disobeyed the court order that he not interrupt once the jury was brought out. He did that immediately upon the first juror walking in. I believe only a few of the jurors even walked in. He was continuing to talk. I immediately removed them from the courtroom to minimize the impact of his disruption. It was clearly disruptive, but again, he is asking to come back, and I will honor that request. I will further advise him, though, that should he interrupt during the jury instruction phase of this trial by either objecting or raising issues that have no bearing on the advisement to the jury by this court of all of the jury instructions, I will consider admonishing him in the presence of the jury or simply removing the jury so that then I can admonish him and then making the appropriate record. All right, with that, since he's asking to come back, we will take a pause. We'll recess. We'll come back in when he is set up in this courtroom. Thank you, everyone.
Wow. I mean, this is really above and beyond what she should have to do. I mean, honestly, she's, bless her heart. That's all I know. Just bless it. Just absolutely. That's all I know to say. Bless it. And that, y'all, is a Southern term. Bless it. I don't know how to explain it. It's a little more than, it's not quite the same as bless your heart, because bless your heart has like multiple meanings and not all of them are nice. But it's like, how do I explain it? Like, in this case, like I'm frustrated, like bless it. Like that, I suppose, is the best way to explain it. Allie and I were talking yesterday. She was so sweet to let me up on her panel and give my opinion on this situation and the interview in the Quentin Simon case. And I forget what we were talking about, a turn of phrase that Leilani used, and not just Leilani, actually, also Billy Joe. And it wasn't like a, it's not a colloquialism is what I was trying to explain, that they used. It's not a Southern phrase. So yeah. I wonder how the jury feels. Like they show up, right? They go to where they're supposed to go. They're in the jury room, right? They're waiting. And then what? Then they're told, okay, we're going to bring you into the courtroom, right? Like 2 jurors or whatever it was get like 2 steps in the courtroom, and they're like, bro, what is this doing? Why is it doing this? Hold on a minute. Why are we still behind? Hold on. Let me stop sharing this and fix it. Hold on. Because that's going to make me crazy if I have to keep fixing it. Anyway, they keep getting brought, in and out and in and out and in and out. Oh, sweet Jesus. Hold on. All right, hold on. Sorry, you guys. This is what I don't like about this. Maybe what I should do is if I do pause, I'll just speed it back up because he's already back on the BS. So give me just a second. I want you guys to see. All right, hold on. All right. All right, here we go. Oh, cripes. I wanted to not have that up here.
Thank you, everyone. Please be seated. I'll have the jury brought out then. Record to reflect we are all back in this courtroom.
Before the jury's brought out, can we address subject matter jurisdiction, Your Honor? Before the
Absolutely
jury's
not.
brought out.
Absolutely not.
Is that a tacit agreement that you don't have to answer those questions as a public servant, Your Honor? So are you going to act in dishonor?
Mr. Brooks,
Are you going to act in
I've
dishonor?
already addressed your requests.
It hasn't been proven
Repeatedly.
for the record, Your Honor. It
The
should
jury
be.
is on its way,
They're not out yet, though.
but
man.
they're on the
You
way.
held me in contempt.
I'm not
You held me in
addressing these
contempt
matters,
before.
sir.
Have I acted in dishonor, Your Honor? You held me in contempt without me being in dishonor. How have I dishonored the court? Have I acted in dishonor? Have I rose my voice or argued with Your Honor?
You're doing it right now. What are you
Have I
talking
disrupted
about?
the
Mr.
courtroom
Brooks,
in
you're
any way?
back in this courtroom at your request. The jury is coming
I
out.
never should have
Please
been.
be respectful of their time
I
and of this
have
process
been. They weren't
and
even
the
out
dignity
before.
of the proceedings.
They weren't even out before when I was trying to address what needed to be
Mr.
addressed
Brooks.
before they came out.
You're just
am I
attempting
acting
to
in
disrupt the
dishonor?
proceedings.
Am I acting in
Yes.
dishonor?
Just answer him. Tell him he is.
So that's a tacit
All
agreement
rise
that you
for the
don't.
jury, please.
It's a tacit agreement that you don't have to answer questions as a public servant,
All
right?
right, the jury.
No
is
jury's
not
out.
Mr. Brooks.
No jury's
close the
out.
door.
I was trying to
Mr.
address
Brooks,
this
they are
before they
right
came out.
outside this door. I am not going to do this with you this morning. You either
I'm not
abide by
doing-
these rules
Am I
and
acting in
stay
dishonor?
quiet,
Am
or
I
you will
acting
be
in
in the other
dishonor?
courtroom.
Am I acting in dishonor?
Yes, you are acting
How?
in dishonor.
How?
You are disobeying the direct order of this court to respect the decorum and the dignity of these proceedings. You are merely attempting to delay.
I don't care what you think. That's not accurate.
Mr. Brooks, I am having this jury out. And if you
you're
say
making
one word when that door opens,
you're making a tacit agreement.
then you will forfeit your right to be present.
So you're acting in dishonor, then, Your Honor.
All right, the jury may come in.
You're acting in dishonor by making a tacit agreement that you don't have to answer any questions as a public servant. You're not holding up to your oath to protect the
All right, the
Constitution.
door is open and he's talking.
Okay, so you're gonna hold me in
All right.
contempt?
The jury cannot come in. Never mind.
Are you gonna hold
All
me in
right.
contempt?
Mr. Brooks is going to be removed. We're in recess until that.
How
can be
am I
accomplished.
acting in dishonor?
You guys, I very rarely am at a loss for words, as y'all know. And even I am at a freaking loss for words at this moment. This is ridiculous. Like, I'm going to need you to get your act together, sir, so that we can get through this. We have 170 pages. Isn't that what it is? Of jury instructions to get through. We have not been able to get through a freaking sentence because you're over here acting a straight fool. This is not the time for you to be asking all your 11 billion different questions. She's already told you that. Lord Jesus, fix it. All right, let me speed him up so we can get this show on the road. This is I don't even know what to say to this. Like at all. Jesus took more than the wheel, apparently. Jesus took access to the house. Have I acted in dishonor? Bless it. Well, I will say this, Kez. I don't see that even happening because as far as that goes, because the record is very, very clear. The record is very, very how do I want to say this? The judge has done an excellent job of
Thank you, everyone. Please be seated. We are
making
back on. The record
sure.
appearances are as they were before. The record to reflect that Mr. Brooks is now in the other courtroom. I currently have him muted so that I can add to the record. I have confirmed he can hear and see as well. I would know he does have the headphones. Can I?
All right.
We
there
are back
go.
on. The record appearances are as
There
they
we
were
go.
before. The record to reflect that Mr. Brooks is now in the other.
Oh, I would be too,
courtroom.
Navigator. I would be so
have him
annoyed.
muted so that I can add to the record. I have confirmed he can hear and see as well. I would note he does have the headphones on while in that courtroom. He just lifted them up as well, or at least part of them. This court has previously relied upon the U.S. Supreme Court case of Illinois versus Allen, wherein the United States Supreme Court indicated it is essential to the proper administration of the criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. We believe trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. We think there are at least three constitutionally permissible ways for a trial judge to handle such a defendant, including 1, bind and gag him, thereby keeping him present; 2, cite him for contempt; or
I will be
3,
right back, but I'll be in
take him
chat.
out of the courtroom until he promises to conduct himself properly. I understand Mr. Brooks is waving to the court. I'll address that momentarily. But the bottom line is there is a history of repeated disruptive behavior by Mr. Brooks. I warned him after he came back in. The first thing he wanted to do was address subject matter jurisdiction. That is, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. I've issued a written decision. He has yet to appeal that written decision. He has that right to file an interlocutory appeal. I would also note at no time during this case has jurisdiction
All right, I'll be right back for
challenged when he was represented by an attorney. So I warned him, given the importance of the proceedings and the need for the court to advise this jury without interruption, he was removed once again. I will not bring him back into this courtroom unless he is willing and pledges to conform his conduct and pledge to not interrupt by making any statements when this jury is present and during the court reading all of the jury instructions. I will unmute him so that he can indicate what he would like to say to the court. You are unmuted, sir. Go ahead.
Can y'all hear me?
We can.
First of all, at 9:25, I would like the record to reflect that the prosecution was making dispiriting remarks and gestures in pursuant to what just happened. I don't appreciate it, and I think that that is very disrespectful. For the record.
And again, I'm trying to figure out how did I act in dishonor to be removed from the courtroom? How have I acted in dishonor? This is a whole nother. How have I acted in dishonor?
All right, I'm going to mute Mr. Brooks. I'm not going to answer that question. I've made my ruling as far as anything that was done by the prosecution. I was not in the courtroom. The jury was not present. Whatever happened, if anything at all, was done outside the presence of the jury. If there is anything the state wants to put on the record right now, I'll give you that opportunity. Otherwise, I am going to bring the jury out, Mr. Brooks. If you want to come back into this courtroom, you need to write your request down on a piece of paper. And when you do that, pledge to this court that you will not interrupt these proceedings. Without that, I will not bring you back into this courtroom. Anything the state wants to put on the record?
I have a question, Your Honor. I don't have anything directly in response to Mr. Brooks' last statement.
All right, go ahead.
Yesterday afternoon, when we had the 4-screen up, there was a wider view of the courtroom so that the jury box could be seen. Is that possible to do
Yes,
again?
it is. We can take the witness stand camera and pull it out so that he has a view of the jury box as well. I can't angle it, but I can
Yeah.
do that.
And for the record, when you do that, then he can see the jury box. So I would ask that that be done before
Right,
we.
please do that, Madam Clerk. Well,
But they don't have it.
it's not on Zoom, and so the court TV would be able to fix the camera on me and not on the screen, so that they don't capture any of the jurors, and they're directed to honor that and do that. Same thing, obviously, with our still photographer. If there are any images captured of Mr. Brooks, as you can see, the camera is being zoomed out. You would need to avoid capturing members of the jury.
Thank you, Your Honor. The record should reflect you have zoomed out the camera, and it looks
Right.
like about 90% of the jury box can now be seen in the view if Mr. Brooks chooses to do
Right.
that.
Mr. Brooks, I'll unmute. What is it you would like the court to address?
How can you rule that I don't have the right to be present in the courtroom?
I've answered that previously. I've made my findings under Illinois versus Allen. He continues to interrupt, even if it is by asking questions. I've made my ruling. The record stands. It speaks for itself. And I intend to have the jury brought out. I need one moment before I do that. And so I'm going to just take about a 2-minute recess.
All right, sorry about that, you guys. I let Nestor out with me to go potty, and he wanted to dilly dally, and I had a little bit of difficulty bringing him inside. He's getting well, he's in the room, so a little bit OLD, and I can't quite tell if the if he's ignoring me or if he legitimately can't hear me. So what I've been doing is like walking out to him. Yeah. I have no idea, Amelia. Look, here's what's happened because I think you said you you were making memes. So what has happened is basically the jury was brought in the first time, and upon I think two jurors might have crossed the threshold of the door into the courtroom, and Mr. Brooks started in about subject matter jurisdiction, and then dishonor, and yeah, okay. So she removed him. We went to recess. The jury was brought back in. She made a record of the whole uh why he was removed, yada yada yada. Okay. Then he started waving his hands in the air like he just don't care, and she unmuted him, and he said he wanted to come back. So there was another recess. The jury was removed. He was brought back in. The jury was brought back. The jury was brought back in, and he started up again and has since been removed. Then the jury, um, they were removed too. Then there was a recess. The jury was brought back in. The judge went on record and she just unmuted him. He said what he said. And now we're back on another recess. Now, I don't know why we've taken another recess. To be honest with you, I have no idea because I don't know why another recess was needed. So I just want to make sure we're all the way caught up. I think we are. Yeah. All right. Yeah, because it won't let me, because it changed it back to normal. So. So yeah, now we're just chilling, waiting for this recess to be over, and yeah, for court to resume. Which I low-key want to take my own recess and make another cup of coffee, but I'm not gonna because it's like 10:41 and I don't need another cup of coffee. I think I'll be all right. I think I can make it. Let me just stop sharing right quick and make sure that it's not back in recess. All right, let me go like this. We're not back from recess because I don't like to be waiting. I'll know how I feel about that. Patience may be a virtue, but it's one I don't possess. All right, we're still at recess. Excuse me. So now we're just hurry up and waiting. Court has been in session. Okay. So I've been live for an hour, 42 minutes and 34 seconds roughly, because the seconds keep ticking. I started my live at 9. Court started at 9:30. So roughly the court has been in session since for like an hour, and we've done nothing, but nothing has been accomplished but his interrupting, quite frankly. And I'm not even I'm not it's I'm not upset with the judge or anything like that. I She has a ton of jury instructions to go through, and said that really she didn't expect to get to the actual closing arguments until like after lunch. But at this rate, I, I don't I don't think court is going to end until, shoot, probably after 5. And I mean by after 5, I mean after 5 local time, which they're on Central Time, so they're an hour behind me. I'm on Eastern Time, obviously, if they're an hour behind. I don't understand why I feel the need to constantly state the obvious, but here we are. Um, so yeah, I think this is going to be quite a long day. Oh boy, Kez chick. Mm-mm. I don't think in all my history of having a channel and having mods, I've ever asked any of my mods to mod that early in the morning, because I don't even know why I would be up at 5:30 in the morning. I don't know what business I would have to take care of that required me to be up at that hour, because I like to schedule all of my business for reasonable times. Yeah, I know. I absolutely, Kez is dedicated. And yes, sure, I absolutely know better than to try to pull that kind of shenanigan. I have the best mods. I really do. Although I be seeing other channels and I see their mods like, reminding the chat to give the stream a thumbs up and all that stuff. And I'm just teasing. I can say, I can honestly say that myself. I don't need the mods to do all that for me. Yes, all those. Shmina. As you know, or maybe you don't if you're new to the ward, Shmita is the channel manager and the complaint department. So, should you have, she's also the suggestion box. Should you have a need to speak to my manager, please direct all correspondence to Shmita. Her email, I believe, is in the About section of her channel, Shmita's Pictures. If you need to, but I do want to say this. Mark, of course it counts. Of course it counts if you give the title to yourself. Why wouldn't it count? Of course it counts. Holy Hannah, why are we still on break, you guys? I can't. Why? What is happening? How much more break do we need? Shmita, I'm going to highlight this comment and read it aloud for the members of our audience who are AFK and cleaning or doing whatever. Ha, ha, ha. Just let it be known for the record that my patience is way thinner than this judge's. Ha, ha. The record is so noted. I don't know if you guys can hear that because he's in the other room, but Nestor is doing that reverse sneeze that dogs do. It always happens when he goes outside and rolls around in the sand out there. And I just feel awful for him. He's got allergies, bless his little heart. And I tell him all the time, please stop rolling around in the dirt. You know that it aggravates you. And I will say this, I did joke over the summer because of the rolling around in the sand that Nestor was working on his Halloween costume, getting a head start, and that he would be going as Pigpen. And I don't know if he took that joke for serious or what, but I cannot get him to quit rolling around in the sand. Bless his heart. I love him so much. And I try to have rational conversations with him and explain to him that the sand gets up in his nose and it irritates his airways. And then we get to the situation where he's doing the reverse sneezing and he just looks miserable, and to no avail. I tried pictures, that didn't work. I've begged, I've pleaded, doesn't work. Even Alice is upset by it. She's like watching. Bless her heart. She's quite upset with me at this time because you guys remember that that cat that used to come in my backyard when he was little, and I said, okay, he's got to have people because I don't see him or whatever. Well, he's back and now he's a cat. But the weirdest thing is he has this cry like a little kitten. It's the cutest thing, but he's back to hanging out in the
All
backyard.
right, we are back on the record. Appearances are as they were before at 9:45. Mr. Brooks sent a note that says, under Illinois v. Allen, I request for the second to be present at my trial. I never consented to not being present, nor did I act in dishonor because he has not made a pledge to conform his conduct as is required under Illinois versus Allen. He has not reclaimed his right to be present, and we will continue with him in the other room.
Yes.
I will also make a finding today, and I didn't do this previously, although he's forfeited his right to be present, given the technology, the audio and visual equipment that we have, the fact that we've also backed out the one camera so he can see the jurors. I'll make a finding, even without that, though, that it's the functional equivalent of being present in this courtroom. All right, with that, then the jury will be brought out. I'll remind Mr. Brooks, while he can reclaim the right to come back into the courtroom and make a request, I am going to be adamant that his request include a statement that he's willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings, and specifically pledge to not interrupt the reading of the jury instructions. Until such time, he will remain in that courtroom. All right, go ahead.
I don't know about you guys, but at this point, I'm contemplating my own life decisions. Such as, why did I decide to cover this trial this morning when clearly there's not going to be nothing happening today? Well, maybe there will be now. I hope so, because I can't take any more of this. My nerves is shot. I don't know how this judge is doing it, to be honest with you. Wonder what the issue is now.
Okay, I know what you're saying. Okay, I know.
All right. All rise for the jury.
You're welcome, Mark.
Thank you, everyone. Please be seated. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The defendant is charged with 6 separate counts of first-degree intentional homicide, use of a dangerous weapon. The first count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Virginia Sorensen with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The second count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Leanna Owen with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The third count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Tamara Durand with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The fourth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jane Coolidge with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The fifth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Wilhelm Haskell with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The sixth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin.
Nothing, sugar
caused
beet.
the
We
death of
just now
Jackson
finally
Sparks
got
with
to
intent
the
to kill that
instructions.
person and while using a dangerous weapon.
Yes,
Contrary
Amelia.
to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The defendant has entered a plea of not guilty to each of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. First degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of any count of first degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present with respect to that count. One, as to each count, the defendant caused the death of the victim named in that count. Cause means that the defendant's act was a substantial factor in producing the death. Two, as to each count, the defendant acted with intent to kill the victim named in that count. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The information alleges not only that the defendant committed the crimes of first-degree intentional homicide, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree intentional homicide, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide while using a dangerous weapon. If you are not so satisfied,
You
you
should
must answer the
probably,
question,
rather than work on
no.
his pledge, just be working on his closing arguments. Because let's be honest, we know he
If you
ain't
are
going to stick to
satisfied
no
beyond a
pledge.
reasonable doubt that both elements
Because he
of
doesn't think he
first-degree
has to
intentional
pledge.
homicide have been proved as to count one, you should find the defendant guilty of first-degree intentional homicide as charged in count one. If you are not so satisfied, you must find the defendant not guilty as to count 1. If you find the defendant guilty of count 1, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 2, you should find the defendant guilty of first-degree intentional homicide as charged in count 2. If you are not so satisfied, you must find the defendant not guilty as to count 2. If you find the defendant guilty of count 2, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 3, you should find the defendant guilty of first-degree intentional homicide as charged in count 3. If you are not so satisfied, you must find the defendant not guilty as to count 3. If you find the defendant guilty of count 3, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 4, you should find the defendant guilty of first-degree intentional homicide as charged in count 4. If you are not so satisfied, you must find the defendant not guilty as to count 4. If you find the defendant guilty of count 4, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide?
What do you
using a
think, you
dangerous
guys?
weapon?
Like another
If you are satisfied beyond a reasonable doubt that both
15,
elements of
20
first-degree
minutes,
intentional homicide
and
have
then-
been proved as to count 5, you should find the defendant guilty of first-degree intentional homicide
A
as
break.
charged in count 5. If you
and
are
then
not
we
so
come back
satisfied,
after
you must
lunch
find the defendant not
and hear
guilty
the
as to
closing
count 5.
arguments.
If you find the defendant guilty of count 5, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 6, you should find the defendant guilty of first-degree intentional homicide as charged in count 6. If you are not so satisfied, you must find the defendant not guilty as to count 6. If you find the defendant guilty of count 6, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon?
Yeah, this is definitely
The
going to go
defendant
on
is
a
charged
while.
with 61 separate counts of first-degree recklessly endangering safety.
I mean, it's
use
a ton of
dangerous weapon. The
instructions.
seventh count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly
Aw,
endanger
I'm
the
sorry,
safety of
Kes.
Nicole White under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The eighth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Eleanor Anders under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3
know.
sub F,
So
and
sad.
939.63 sub 1 sub B of the Wisconsin statutes. The ninth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Sasha Catalan Castillo under circumstances which show utter disregard for human life.
How
and while
long do you
using a
guys think
dangerous
the
weapon,
jury's going to
contrary to
deliberate?
sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 10th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Maura Gilchrist under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 11th count of the
Aussie
information in this
Patriot,
case
five
charges that
point
Darrell E.
8
Brooks on or about
minutes.
Sunday, November 21
Did
of
you mean 5.8
2021
or
on
58?
Main Street in the city of Waukesha, Waukesha County,
Yeah, I think
Wisconsin,
they're going to come
did
back pretty
recklessly
quickly.
endanger the safety of Justin Gullickson under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to
1.1
sections
seconds. Now remember,
941.30 sub 1,
all right, I'm going to stop sharing.
939.
Now remember, you guys, when we are deciding or guessing how long it's going to take the jury to deliberate, we are going by the Price is Right rules. Okay. So if you overbid, you're immediately out. Okay. So it's going to be the closest, either like spot on, accurate, or closest to the time. Okay. But remember, again, I can't stress this enough. If you go over the amount of time that it actually ends up being, that is considered an overbid, and therefore you are disqualified. Correct, Amelia Sparkles. The closest without going over. That is the Price is Right rules. That's the only way we do it in this at the ward, by the price. If it was good enough for Bob Barker, it's good enough for Jen Liu. All right. This is what we're going to do. 23 minutes, says Schmida. I am going to go. I'm going to go an hour. And I'll tell you why. Here's my reasoning. I think it's going to take a total of an hour because there's 11 billion pages of the jury forms to fill out. So I'm going to say after it's turned over to the jury, it's going to be about an hour. So that's 60 minutes. That's my bid. All right. Kez has 50 minutes. All right. So here's what we're going to do. I'm going to end this, and and the ward will be in recess until after lunch, at which time we will then go live again to hear the closing arguments. Okie dokies, artichokes. That's what we're going to do. Now, keep an eye on this channel. Obviously, make sure your notifications are set to all, but for me right now, it is 11:10 in the morning, which means it's 10:10 in Waukesha. All right. So somewhere around the 1 p.m., 2 p.m. mark. So 1 p.m. Central, 2 p.m. Eastern. Be looking out because YouTube is funky about if you go live multiple times in a 24-hour period, they restrict you. So just, set an alarm, do what you got to do. I have to go now, babe. I really do. Let's get this stuff done. We know what the jury instructions are going to be, and I want to be fresh to talk about these closing arguments. All right. So keep your ojos peeled. All right. I will be back, and I will see all of you lovelies then. Oh my gosh. It's 2:11 a.m. where you are? No way, Jose. Okay, Corkies, 2.5 hours. All right. We'll see. We'll see you guys here in a little bit, couple of hours, give or take. All right. I will definitely just keep your eyes out for the notifications. All right. Y'all stay safe out there on these YouTube streets and in the real streets because it's dicey out there. All right. I'll see y'all in a little bit. Okie doke. Bye.